Good day! Welcome to Lawyer Up by NDV Law. This is Attorney Nikki de Vega, Managing Partner of Nicolas and de Vega Law Offices. In today's video, I will teach you how to legally dismiss an employee in the Philippines based on redundancy. Dismissal of workers due to redundancy is a management prerogative governed by Article 283 of the Philippine Labor Code. This is one of the authorized causes which an employer in good faith may utilize. The term redundancy is a technical labor term which has been the subject of many interesting cases that have found their way to the Supreme Court. In several of these cases, the Supreme Court has defined redundancy for purposes of the Labor Code as a condition which exists where the services of an employee are in excess of what is reasonably demanded by the actual requirements of the enterprise. Well, succinctly put, a position is redundant where it is superfluous, and superfluity of a position or positions may be the outcome of a number of factors such as overhiring of workers, decreased volume of business, or dropping of a particular product line or service or activity previously manufactured or undertaken by the enterprise. In another case, the Supreme Court stated that redundancy in an employer's personal workforce necessarily or even ordinarily refers to the duplication of work, that no other person was holding the same position that the respondent held prior to the termination of his services does not show that his position had not become redundant. The Supreme Court observed that in any well-organized business enterprise, it would be surprising to find duplication of work or two or more people doing the same kind of work. In such cases, the Supreme Court held that the employer has no legal obligation to keep in its payroll more employees than are necessary for the operation of its business. However, the employer must show adequate and convincing proof that the intended reduction of workforce or the abolishment of positions were necessary. In other words, it is not enough for a company to merely declare that it has become overmanned. It must produce adequate proof that such is the actual situation to justify the dismissal of the affected employees for redundancy. Now, for the implementation of a redundancy program to be valid, the employer must comply with the following procedural requisites. First, written notice must be served on the employees and the Department of Labor and Employment or DOLE at least 30 days prior to the intended date of redundancy. Specifically, the purpose of such previous notice to the DOLE must be to enable it to ascertain the verity of the cause for termination of the employment. The violation of statutory procedural due process on written notice by the employer would warrant the payment of indemnity in the form of nominal damages. The amount of such damages is addressed to the sound discretion of the court, while taking into account the relevant circumstances. In a case, the indemnity awarded by the Supreme Court to each of the complainant was roughly around 50,000 pesos as nominal damages. Finally, the more important aspect in the termination of employment is the payment of the employee's separation pay equivalent to 1 month pay for every year of service. So that is how to implement a redundancy program in the Philippine workplace. If this video has been helpful, kindly subscribe to our YouTube channel by clicking on the subscribe button. You can also visit our website, ndvlaw.com, to learn more about legal matters in the Philippines. This is Attorney Nikki de Vega, Managing Partner of Nicolas and de Vega Law Offices. And I thank you for watching Lawyer Up by NDV Law.